Hello, it's Brian Smith with Risk Reconnaissance, the GovCon insurance guy with the Insurance Office of America out of Atlanta. And today I'm being joined by Paul Ferreira of LexWorks Law Firm out of Tampa, Florida. And we're going to cover a pretty interesting topic today that has to do with performance issues. So thank you so much, Paul, for being part of our discussion today.
Well, yeah, it's one of the things I tell my clients is that there is money to be made with the federal government, but once you start doing business with the federal government, your business will now get a little bit more complicated than it is normal doing a business from business to business or business in the business to business community. And one of the issues that sometimes occurs are contract non-performance. So there's three parties in this. There's the federal government, obviously. There's the prime contractor, or the contractor that actually won the bid or the proposal from the federal government. And then there are subcontractors. These are subcontractors that the prime hires or contracts with to help them perform that contract. So the first issue I want to talk about is when there's performance issues between the government and the prime. So let's say, for example, you want a contract with the government and the contract requires you to produce 100 widgets a month. And now it's the third month into the contract performance, and you haven't met those standards. You've delivered 75 one month, 50 the next, and then 75 the next. First, non-performance issues are hardly ever a surprise. You as a company should see them and know that they're coming. And the federal government will also give you notice, either through written notice, through emails, conversations with the contracting officers on some of the issues. Like most government programs, there's going to be an attempt to help you remediate the situation. Agencies like the Defense Contract Management Agency have the field officers that they can deploy to your factory. Like, what's the problem? Why aren't you getting the 100 widgets out the door monthly? Is there anything that we can do to help you? Is there any problems that we can cure? What can we do to help you catch up on the backlog before there's any penalties put out or through the contract, or there's any breach or cancellation of the contract, which is not something you want to do. Most of the time, if you will comply with that remedial plan, and that's a decision everybody makes and comes together, you should be able to meet the government's requirements. Worst case scenario, if you're not, then the government will issue a cease and desist notice and eventually stop that contract with you. You may then be barred from resubmission, bids or proposals permanently or for a matter of time. It could be years before you can resubmit if you are unable to perform the contract.
Those are very good points. When would legal counsel become involved?
Well, in a perfect world, the legal counsel should be involved as soon as you're responding to that RFP to review that your proposal that you're submitting in to the government and see if there are any issues in there, maybe of concern to legal counsel that may cause you to have compliance issues further down the road. Insurance requirements, other requirements that may be embedded in that solicitation by the government that you should be made aware of. Counsel should already have some familiarity with that contract. As soon as things appear to be not be working out, we've had a conversation with the contracting officer. They're not happy because we only got 75 widgets out the door this month instead of 100. Then you should give notice to counsel, and they should get involved at that time, because that's an opportunity to get ahead of the problem, start reviewing the contract, seeing what the provisions are for remediation, what can we do to catch up, what can we do to fix it based on what's already in the contract. Also to start reviewing the defense federal acquisition rules to see what other options, the client or the prime in this case would have. So the earlier, the better. Unfortunately, that doesn't happen too many times. By the time you get the call from the client, it's like, the government's here at my door. What do I do now?
Hey, Paul, what about the prime and the subcontractor performance issues? How would those be best managed?
All right, those are governed by the contract. So as soon as prime is responding to the government solicitation, they should be lining up their subcontractors on hey, if we win this contract, we want you to help us perform this contract. So, and those contracts are between the prime and the sub. So those are business to business contracts. Although there may be some requirements, we call that pass down language, that the government will require that the primes the contracts contain certain clauses, and those clauses will be laid out. For whatever reason, they have to be in the contract. But so now, certain other clauses, though, the prime is free to negotiate with the subcontractor by themselves. One thing I try to do in the case of non-performance or any issue between the prime and the sub is try to reduce litigation costs. And how do I do that? By putting a clause in there that should there be a dispute between the prime and the sub, both parties agree beforehand in this contract that it will first go to mediation. If it doesn't resolve in mediation, then it goes to arbitration. If it doesn't resolve at arbitration, then you can go to litigation, but normally in a forum, in a place that is convenient or most convenient for the prime. The contract may require and will likely require that there be written notice from the prime to the sub about issues with contract performance, outlining what they may be and citing certain provisions in the contract that suggest or say that if you don't comply, if you don't fix it within the next 30, 60, 90 days, whatever, we will cancel the contract pursuant to clause XYZ in the contract. So those are the ways that you can address any issues between the prime and the sub. Normally, primes and subs have worked together before, so contract issues are usually unique or rare because they have a standing relationship as they go into this contract with the federal government in the best places. But there are always cases where you start off with a new sub and they're not performing, and then the contract would govern how those disputes would be resolved.
What should companies be thinking about with regards to non-compete clauses, and what exactly is a non-compete clause?
Right. The most common non-compete clause you'll see is an employer-employee non-compete clause, which requires the employee not to do certain things or engage in certain activities. If the full-time employee relationship is in existence, an employer has a lot more discretion on what restrictions it can impose on the employee than when that employer-employee relationship has been terminated. As long as the restrictions aren't discriminatory in nature, they can ask you not to engage in any dangerous activities on the weekends because you're a valued employee, they're compensating you well, and they want to make sure you're going to be able to perform your part of the bargain. In some states, those non-compete clauses are not allowed, are not authorized by law, are not enforced by law. The courts will not enforce it. In other states, they are. And in those states where they are, there's normally still requirements that they meet, that those clauses have to meet in order to be enforceable in court of law. And those requirements are usually reasonable in duration or time and reasonable in geographical area.
From a non-compete clause perspective, what are some examples perhaps that the government contracting companies or organizations need to be aware of if they're preparing to release an employee?
And so one of the key issues that you'll be looking at is what state is that employee being hired in and what state is that employee going to perform their duties in. So to give you one example, a Southwestern company was expanding, defense contractor. They wanted to move into Florida to do business in Florida in the defense contracting arena, which is all well and good. They began hiring employees here in Florida, but no one in the company, which is based out of the Southwest, took the time to look at the non-compete clauses and redraft them in accordance with Florida law. So they quoted other states like Texas, New Mexico, Virginia law, where the company had a presence. But when hiring these individuals, whatever HR person was during the hiring process, didn't take the time to look and realize, wait, this is new territory. We haven't been in here before. Does our contract conform with those state laws? So at the time when the employee decided, I'm going to cut ties and start my own company, which could or could not be considered in direct competition to his former employer, they had very little arguments to make because the contract applied to the non-compete clause referred specifically to other states and not the state where they were hiring an employee.